Byton Burkhardt explains what needs to be considered when drafting employment contracts in accordance with German law. This is Paul. He's a chief human resource officer, and he's just decided that Linda should be a new member of his team. Linda should start work soon. But Paul follows a principle. No employee should begin their service without a professionally drawn-up contract. Every contract must describe the nature and scope of the work, quantify the amount of remuneration, and define the duration of the role and the period of notice. After all, with agreements that are only made verbally, there can be misunderstandings. If no contract has been made, statutory provisions apply. However, these alone do not guarantee that all parties will be satisfied. That's why Paul draws up a suitable contract. In principle, its composition is subject to the freedom of contract. However, all agreements must be in line with any possible collective and shop agreements and must not contradict the law. Otherwise, they're null and void. The law prohibits agreements which, for example, make it difficult for the worker to give their notice. That would be the case if the employee has to serve a longer notice period than the employer. Also, the company may not reserve the right to cancel a bonus that has been earned. The right of withdrawal does not apply in such case. The scope of any fixed-rate overtime compensation must be determined in the contract and should be at an appropriate rate compared to the salary. Otherwise, the fixed rate is invalid, and the employer would have to pay the overtime retrospectively. To appoint Linda, Paul uses a standard contract. In doing so, he applies proven regulations that his company uses all the time. As a matter of routine, he shows the draft contract to his lawyer, who looks at the details closely and finds a mistake. In the contract, Paul has agreed to a voluntary monthly bonus for Linda. The corresponding formulation has been used commonly by his firm. However, the use of pre-formulated clauses is no guarantee of their effectiveness. The lawyer advises Paul not to use that particular formulation. In the event of a dispute before a court, the voluntary bonus would be seen as a compulsory payment. Paul thinks and decides to withdraw the bonus. Instead, he increases the basic salary a little. Now Paul can provide his new assistant with a solid contract. She's starting work tomorrow and will support Paul successfully.